Hello, my name is Erika. I filed a application for a judicial review in the High Court of New Zealand. This was to challenge the decision not to release the Pfizer contract. I will share my screen and go through what is in that particular claim. The claim is on my screen here. In the High Court of New Zealand, Wellington, under the Judicial Review Act 2016, in the matter of a right of review under the Official Information Act 1982 and Section 32 of the Ombudsman Act 1975. I am the applicant, Erika Whittome, and the respondents are the Director General of Health under the Ministry of Health, the Ombudsman, and Pharmac, the Pharmaceutical Management Agency. So this is my fourth amended statement of claim, and a hearing has been set down for the 11th of June 2026 in the Wellington High Court. The applicant, by filing this notice, elects to have the High Court conduct a review of the Director General of Health's decision to withhold the contract between the New Zealand Government and Pfizer for the supplying of the COVID-19 vaccine, Comirnaty BNT162b2 messenger ribonucleic acid, and that's referred to as the contract. The applicant requested parts of the contract under the Official Information Act. The requested information was withheld by the first and third respondents. The applicant complained to the Ombudsman, which, as Collins J. said in the judgment of Kelsey versus Minister of Trade, those who are dissatisfied with decisions refusing to release official information or with conditions imposed upon the use of any official information may ask the Ombudsman to investigate and review the decision in question. The Ombudsman refused to investigate the applicant's complaints regarding her OIAs and has not provided any evidence capable of demonstrating reasons for not providing the information sought. The applicant brings this action against the respondents to ask the courts to compel compliance with the Official Information Act, Part 1, Section 3. By Section 15 of the Official Information Act, 1982, the first and third respondents are required to comply with Section 15.2 of this Act. Section 15 of the Act imposes a duty on every department, minister, or organisation to whom an Official Information Act request is made, as soon as reasonably practicable, and in any case not later than 20 working days after the day on which the request is received by that department or minister of the Crown or organisation, to decide whether the request is to be granted and give or post to the person who made the request notice of the decision. Grounds. As grounds, therefore, the applicant alleges as follows. The applicant brings this action against the respondents to compel compliance with the Official Information Act, 1982, OIA, Part 1, Section 3. The decision of Kelsey explains the purpose of the OIA, and Kelsey was a decision from 2016 about the Trans-Pacific trade agreement being kept secret from New Zealanders. The title to the Act explains it makes official information more freely available and protects official information to the extent consistent with public interest. Section 4 explains that the purposes of the Act are consistent with the principle of the executive government's responsibility to Parliament. The purposes of the Act include increasing progressively the availability of official information to the people of New Zealand in order to enable their more effective participation in the making and administration of laws and policies, and thereby to enhance respect for the law and to promote the good government of New Zealand. Protecting official information to the extent consistent with the public interest. The respondents' reasons for not complying with the OIA from Section 9 of the Act were as its release would likely unreasonably prejudice the commercial position of the person who supplied the information, to protect information that is subject to an obligation of confidence and making it available would likely damage the public interest, avoid prejudice to measures protecting the health or safety of members of the public, or enable a minister of the Crown or any public agency or organisation holding the information to carry on without prejudice or disadvantage negotiations, including commercial and industrial negotiations. The applicant says these grounds were unreasonably applied and that there has been procedural impropriety. The duty at Section 15 is subject to limitations at Section 9 of the Act. The respondents have not provided any evidence capable of demonstrating that Section 9 reasons for not providing the information which is sought have been properly engaged. Furthermore, the Ombudsman refusal to investigate the applicant's complaints is further procedural impropriety. He did not sufficiently substantiate his decision not to compel the other respondents to release the information. The Ombudsman did not fulfil his duty and functions under Section 13 of the Ombudsman Act and instead invoked Section 17(1)(f) of the Ombudsman Act 1975. Having regard to all the circumstances of the case, following preliminary inquiries and investigation is unnecessary. Or, having commenced an investigation, further investigation is unnecessary. The Ombudsman relied on grounds that it is unnecessary, which the applicant says is insufficient, especially given the public interest in releasing the contract. Statement of facts, background. In autumn 2019, several researchers inside the Wuhan Institute of Virology became sick in autumn 2019 before the first identified case of the outbreak with symptoms consistent with both COVID-19 and common seasonal illness. And that is a quote from the White House report, which is footnoted down here. On January 30th, 2020, the World Health Organization declared COVID-19 a public health emergency of international concern. In October 2020, the WHO reported on the severity of the COVID-19 disease. In people younger than 70 years, infection fatality rates range from 0.00% to 0.31%, with crude and corrected medians of 0.05%. And that's a quote from a World Health Organization report that was published on the NIH, the National Institute of Health website. Infection fatality rate, COVID-19 inferred from seroprevalence data. The WHO reported that the COVID-19 disease had a very low impact on those aged under 70 to the introduction of any vaccination in the year 2020. On 31st of December 2020, the New England Medical Journal published the phase 2 of 3 phase trial results of the efficacy of the Pfizer vaccination. This data set and these trial results are the basis for an application for emergency use authorization. The medicine did not have full regulatory approval and clinical trials remain ongoing. On the 14th of December 2022, the Ministry of Health shared in an OIA that it purchased 18.58 million doses of the Pfizer vaccine. Request for the contract. The applicant observed that several OIAs requesting information about the contract had been met with a decision to decline to release it. These requests and declines were published on the FYI website, including John Armstrong's request, the former second applicant to this claim. The applicant, Ms. Whittome, requested 3 specific sections of the contract and 2 separate OIA requests. Requests for commercially reasonable efforts in the contract. On the 16th of April 2023, the applicant requested information from the Ministry of Health regarding commercially reasonable efforts in the contract under the Official Information Act. Please would you share the commercially reasonable efforts details on the contract you have with Pfizer for supplying Comirnaty to New Zealand. I request the details in this contract on the efforts Pfizer are delivering as part of this contract on medicine safety, medicine efficacy, and pharmacovigilance. Response to OIA request. On the 26th of April 2023, Jan Torres, Manager of Official Information Act Services at the Ministry of Health, withheld the commercially reasonable efforts information citing sections of the Act. The contracts between Pfizer and the New Zealand Government are withheld in full under the following sections of the Act. as its release would likely unreasonably prejudice the commercial position of the person who supplied the information, to protect information that is subject to an obligation of confidence, and making it available would likely damage the public interest. Official Information Act request for product warranty and purchaser limitations. On the 22nd of April, the applicant requested information from the Ministry of Health regarding the purchaser limitations and the product warranty in the contract. Her request said, I request all emails, contract information, procurement information, communications and reports pertaining to the purchaser's limitations on itself and any of its third parties in the contract with supplying the Pfizer Comirnaty medicine. Please include any limitations on the organisation known as MedSafe with regard to performing its routine pharmacovigilance activity as stated in the procurement agreement with Pfizer. Please include any additional incentives or benefits to or from any other parties or agents to induce any other parties to perform any part of medicine's procurement agreement. Provide all nature of those limitations and provide any and all supporting communications and after the product's procurement date. Please provide all the warranty information of this medicinal product from the procurement agreement and any associated emails. Communications regarding this. Response to purchaser limitations. On the 17th of May 2023, the Ministry of Health withheld the purchaser limitations in the contract, citing sections of the Act, as its release would unlikely unreasonably prejudice the commercial position of the person who supplied the information, to protect information that is subject to an obligation of confidence, making it available would likely damage the public interest. Response to public warranty. On the 12th of June, Pharmac responded and withheld the product warranty information that the applicant had requested. Thank you for your request, partially transferred to Pharmac on 12th of May 2023 under the Official Information Act 1982 for information regarding to the warranty information of Pfizer Comirnaty vaccine. You requested, please provide all the warranty information on this medicinal product from the procurement agreement and any associated emails, communications regarding this. The information we hold relevant to your request is the warranty terms in the procurement agreement contract. This information has been determined as commercially sensitive, and therefore releasing this information could prejudice Pharmac's ability to negotiate in the future. Therefore, we are declining to provide you with the warranty information for the Pfizer Comirnaty vaccine procurement agreement under Section 92J of the Official Information Act. Applicant's complaints. On the 19th of June, the first applicant complained to the second respondent that the information in her 22nd of April request for product warranty and purchaser limitations had not been supplied. And there's some numbers there of the complaints. The Ombudsman responded on the 13th of December. The Chief Ombudsman is unlikely to investigate this complaint on the basis that it is unnecessary. The Ombudsman came to the opinion that there was no specific detail contained in the government's Pfizer Comirnaty procurement contract that should be released. And I note here that these reasons here differed from the earlier reason, which had been Pharmac's reason to the applicant for the 12th of June OIA response when Pharmac withheld the product warranty section. On the 14th of December, the applicant requested the matter remained open because the information requested had not been supplied. On the 21st of December 2023, the Ombudsman closed the applicant's complaint on the grounds that the Ombudsman had recently investigated a range of complaints involving requests for the same information you are seeking and published his final opinion that the Ministry was entitled to withhold it. The Ombudsman shared a final opinion document with the applicant. He listed the Minister of Finance and the Minister for COVID-19 response as having or had in the past custody of the contract and have standing in the applicant's claim. This is the first page of the final opinion. Chief Ombudsman opinion on OIA complaints about refusal of COVID-19 vaccine contracts. So this is under the Official Information Act, a group of 17 requesters. We've got the Minister of COVID-19 Response, Minister of Health, Minister of Finance, and the requesters for the copies of contracts with Pfizer Janssen, Oxford, AstraZeneca, and Novavax for the supply of COVID-19 vaccines. Ombudsman Peter Boshier, no longer the Ombudsman, by the way. And there's some case numbers, and the date was 19th of June. The Ombudsman recommended that the Ministry of Health work with officials from Pharmac and Treasury in consultation with the COVID-19 vaccine suppliers to develop a summary statement for public release by the 18th of September 2023. The applicant relied on the Ombudsman's information to name the respondents for her previous versions of this claim. I said earlier this is the fourth amended claim. Those other parties had been listed as respondents and Crown Law objected, and now we're down to the respondents we have now. There's been no summary statement released to the public by Pharmac and Treasury at this time. Procedural impropriety and public interest. The Ombudsman declined to investigate not only the applicant's OIA request, but also 17 other complaints to him against the respondent for withholding the contract. The Ombudsman recognised the high public interest. There is high public interest in the greater transparency regarding what the government committed to in these particular vaccine contracts. I agree that there is strong public interest here, both in the accountability of ministers and public officials for their decision-making when negotiating and entering into these contracts, and in the promotion of responsible and prudent financial management. The complete particulars of all the 17 requesters for the contract, the case numbers and the case grounds are not shared in the Ombudsman's final opinion. There are only a few lines of these particulars in the first page of the final opinion. It is not clear to the applicant if her complaint was indeed even considered in this final opinion document, or if the Ombudsman used a blanket basis to agree that the other respondents could withhold the parts of the contract that she had requested. It would be helpful to the applicant for the second respondent to share these particulars of the other 17 complaints to the Ombudsman in their statement of defence. I have the statements of defence, no particulars have been shared. There is an Act of Parliament petition published 30th of July 2024 with 18,911 signatures to release the Pfizer contract, demonstrating continued public interest, and that's a footnote to the petition of Kirsten Murfitt, release the Pfizer biotech contract for the supply of COVID-19 vaccines. Thank you, Kirsten. Summary statement from the Ministry of Health. The final opinion referred to in the 18th of December 2023, dated summary statement from the Ministry of Health. The final opinion referred to a 18th of December 2023, dated summary statement from the Ministry of Health. However, it contains no information that the applicant requested on purchaser limitations and commercially reasonable efforts. The MOH summary statement briefly mentions product warranties. The contracts were subject to warranties for the New Zealand government and for suppliers. It was agreed that suppliers were required to meet New Zealand's quality assurance and regulatory approval requirements administered by MedSafe, which would impact our purchase and supply obligations with suppliers. The Pfizer medicine was imported under the Medicines Act and was granted provisional medicine approval. And down here, this is a footnote to the Gazette notice for that. Section 20, subpart 3 of the Medicines Act provides no warranty under New Zealand law. No consent given under this section shall be deemed to warrant the safety or efficacy of the medicine to which the consent relates. No warranty exists under the Medicines Act 1981, which is the New Zealand law for importing medicines. Therefore, the summary statement insufficiently shares the information on the product warranty contained in the contract. The applicant says the summary statement is further obfuscation and a failure to comply with the Official Information Act. Ombudsman's response. The Ombudsman agreed to withhold the contract by virtue of sections 92B2, BA2, 2C of the Act. I read those out earlier. These are the same sections that were invoked for the earlier responses to OIA of the applicants. The Ombudsman used blanket basis and the same reasons as the Ministry of Health for withholding information. Procedural impropriety. In his various responses, the Ombudsman did not address the first applicant's request for the product warranty in the contract, which is withheld under 92J of the Act by Pharmac. Now we've got a new letter, J. He has a duty to investigate the applicant's complaint. On the 18th of August 2023, a briefing to the Minister of Health says the Minister of Justice notes that public health advice is that the current risk of COVID-19 is low relative to other periods of the pandemic. The key measures of COVID-19 infection have declined since the last assessment and remained stable through winter, and the incidence of hospitalisations is reported to have stabilised. This is my heading, a product not fit for purpose and no demand for it. And I would say it's had no prophylactic effect whatsoever. The MOH recognises that COVID-19 disease is clearly no longer a threat. The infection fatality rate was always low for the disease, and the MOH used persuasion and factoids in its advertising for the COVID-19 vaccinations. And you can see these factoids here. Which I won't bring up, but there's the response there if you want to look up OIA 31668. Therefore, the applicant says there can be no good reasons remaining to withhold the contract. On the 5th of May, the New Zealand COVID case count was 2.6 million, with 13.1 million COVID vaccine doses administered. Now, those footnotes are from Health New Zealand, from their website. As of May 2024, current cases and vaccine data. Demonstrating the drug is ineffective and vaccination failure. The warranty section in the contract remains of interest to the applicant for the reason that it appears that it was ineffective and therefore not fit for purpose. The expenditure of taxpayer funds on a colossal scale for an ineffective product is one of intense public interest to taxpayers, of which the applicant is one. So footnote 36 is this report from Treasury about $68 billion spending, which is an article from the New Zealand Herald there. The applicant's proceedings to release his contract. On the 4th of April 2024, the applicant filed this claim to release the contract in the High Court, Auckland, to have the fees waived. On the 15th of April 2024, the filing fee waiver was declined by Auckland High Court Deputy Registrar David Slight, who asserted this proceeding does not meet the current criteria for determining when a proceeding concerns a matter of genuine public interest. On the 8th of July 2024, Justice Whātā declined a further application to waive fees. I do not consider that the proceeding raises an issue of law of significant interest to the public or a section of the public. The applicants note that this is a contradiction of the Ombudsman's final opinion that recognised high public interest. On the 23rd of September 2024, the former applicant John Armstrong and Ms. Whittome filed and paid the fee of $702 by raising money online from 21 members of the public interested in releasing the contract. On the 7th of November 2024, the counsel for the respondents filed for better particulars. No statements of defence were filed by the respondents. On the interlocutory issue and judgment. On the 2nd of December, the counsel for the respondents sent a memorandum to the court seeking orders for the Minister of Finance and the Minister of COVID respondents to be removed from the applicant's claim. The first respondent also sought an order substituting the Director General of Health for the Minister of Health as the first respondent. I think we're on Director General of Health number 3. There was Bloomfield, Sarfati. I think a third one's resigned. Back to this. Paragraph 57. Orders were sought by Crown Law to remove the 3 vaccine injured applicants and 2 applicants who had not complained to the Ombudsman about their Official Information Act requests not being answered. The applicant requested clarity on whether Pharmac should be an applicant. On the 16th of March, and I think the state I've got wrong here, but that's okay. It was in March or April 2025. A hearing took place for the interlocutory issues in Wellington, and then Justice Grau delivered a decision that the 3 vaccine injured applicants were to be removed as applicants, and the applicants who had not complained to the Ombudsman also be removed from the filing. John Armstrong's complaints to the Ombudsman. The facts have changed since Justice Grau's decision, and information has come to light. Paragraph 45 of this decision says, the Ombudsman did not address Ms. Whittome's request for the warranty information in the contract, which was withheld under Section 92J of the Official Information Act. On the 24th of April 2025, the Ombudsman wrote to the applicant that he would investigate the applicant's complaint about Pharmac for withholding the warranty information in the contract in light of the 16th of April 2025 interlocutory decision. The applicant replied and requested that her complaint be actioned. On the 7th of May, the Ombudsman closed the complaint on the grounds that it appears that an investigation is unnecessary into your complaint. The Ombudsman has therefore found relatively recently that there were good reasons for other agencies to withhold the same information you have complained about Pharmac withholding in this case. No particulars of the good reasons were shared with the applicant other than citing the relevant sections of the Official Information Act to withhold the warranty information in the contract. On the 15th of May 2025, the applicant shared her reasons as to why she continues to request the complaint be investigated. However, the Ombudsman repeated his earlier position. I see that an investigation is unnecessary into this complaint, and I'm proposing to use the discretion as Section 17(1)(fi) of OI. John Armstrong's complaint to the Ombudsman. John Armstrong, the former second applicant, also complained to the Ombudsman since Justice Grau's decision. On the 27th of April 2025, John Armstrong complained to the Ombudsman about his OIA to obtain a copy of the contract. On the 16th of May 2025, the Ombudsman responded that his view that it was unnecessary to investigate Mr. Armstrong's complaint. On the 20th of May 2025, the Ombudsman delivered his final view. I refuse to investigate. Justice Grau's interlocutory decision of 26 March says, I have made these decisions because I consider they will enable the judicial review to proceed in an efficient and orderly manner, with the appropriate focus being only on the parties who made the OIA requests and the parties who made the decisions declining those requests. The applicant chooses not to further delay this claim in releasing the contract with further applications to add Mr. Armstrong. Like the applicant, he has had no success with his complaint to the Ombudsman, with the same grounds cited to withhold the contract. Information on the contract's custodians. On the 27th of May 2025, John Armstrong received a response that the contract is held jointly by the Ministry of Health, Treasury and Pharmac. And here's a link to that response there, footnote 49. The applicant and other taxpayers have a right to know what their government is up to when spending their taxpayer dollars on what had been a failed product. This claim has been properly brought for judicial review. The applicant relies on paragraph 35 of the Kelsey decision. The Ombudsman can decline to investigate a complaint under Section 34 of the Act. No application for judicial review can be commenced unless the Ombudsman has declined to investigate and review the decision in question or determined the complaint. This reflects Parliament's intention that those who are dissatisfied with the decision-maker's response to a request for official information should first take their case to the Ombudsman and exhaust that avenue of redress before resorting to the courts. The newly appointed Ombudsman announced that he prioritises relationships over penalties, yet in his refusals to investigate, he is not using his discretion in the way that Parliament intended for the Ombudsman Act 1975, Section 2, Subpart 1. Ombudsman in relation to any function, power or duty under this Act means the Ombudsman for the time being investigating the complaint in respect of which function, power or duty is being exercised. Agreed questions of law. These are from their interlocutory decision. The two agreed questions of law are to be included in the repleted statement of claim, along with the third question in relation to Pharmac's 12th of June 2023 decision. The three questions of law are from paragraph 56 of this interlocutory decision. Challenge to the May 2023 decision. Did the Director General err in law when refusing parts 1, 2 and 4 of Ms. Whittome's OIA request of 22nd of April in reliance on sections 92B2, 92BA2 of the Official Information Act and part 3 of the request under section 18E of the Official Information Act? Challenge to the 12th of June decision. Did Pharmac err in law when refusing part 5 of the 22nd of April 2022 request in relation to warranty information? And the third one is, did the Ombudsman err in law when deciding not to investigate Ms. Whittome's complaint on the basis that it was unnecessary in light of his June 2023 opinion? Relief. Wherefore, the applicant respectfully requests that the court order the respondents to share the requested contract for Pfizer Comirnaty BNT162B2 messenger ribonucleic acid available for use in New Zealand. Order the respondents to produce by a date certain any copies of the contract responsive to the applicant's OIA request withheld. Enjoin the respondents from continuing to withhold any contracts responsive to the applicant's OIA requests. Relying on the High Court rules 30.3, an application for extraordinary remedy that the respondents inform all other OIA requesters of this contract about any High Court decision to release the contract and send a copy of the contract to them by updating their original OIA requests and Ombudsman complaints. Grant the applicant an award of costs, fees, and other litigation costs reasonably occurred in this action, and grant applicants such other relief as the court deems just and proper. And the next couple of pages is the list of my files relied on. Thank you for listening, and I hope to see many of you on the 11th of June 2026 in the Wellington High Court for the hearing of this matter. Thank you.